Our next bill on the agenda is House File 1607. That is Majority Leader Long bill. And since you're no longer on the committee, Majority Leader Long, I will move to lay over House File 1607. And I do see that we have an A2 author's amendment, so I will also move the amendment. And Representative Long, can you please explain the amendment to us?
Happy to, Chair Mueller. So the amendment will do three things. It fixes an inconsistency with regard to the length of sentence for gross misdemeanor DWIs. It clarifies that if a court ordered consecutive periods of probation for different crimes, this would still apply, and it requires the Sentencing Guidelines Commission to modify their policies consistent with the statute.
All right, any discussion to the A2 amendment? Seeing none, all those in favor signify by saying aye. Aye. Opposed? The motion prevails. The A2 amendment is adopted. All right, Representative Long, please explain your bill to us as amended.
Thank you so much, Chair Mueller. Colleagues, the length of our probation terms in Minnesota are failing the basic tests of fairness, wasting resources, and not achieving our goals of reducing recidivism or increasing public safety. Minnesota rightly prides itself on being on the low end nationally for time spent in prison, but we have been an outlier when it comes to probation. While Minnesota has the 6th lowest incarceration rate, Minnesota has the 6th highest rate of people on community supervision. And when you combine these, we are not at all a low punishment state. It is largely a good thing that Minnesota focuses on probation over incarceration. Community supervision has many benefits and if done well can be much more tailored to help individuals succeed and reintegrate. But probation is still punishment, and the balance has tilted so far towards probation that the average probation term in Minnesota is longer than the average prison term. In part, that's because Minnesota's probation limit was the statutory maximum penalty for the offense, which can be as high as 40 years. Thankfully, the Minnesota Sentencing Guidelines Commission took action in 2020 to limit probation to 5 years, except for homicides and criminal sexual conduct. This bill would codify the actions of the Sentencing Guidelines Commission and would take a step that they were unable to by righting past wrongs and making this retroactive. Probation in Minnesota is not a light touch, and it has real impacts on people's lives. Probation can make it harder to keep a job. Routine check-in requirements can impact employment. Treatment conditions can require transportation and scheduling flexibility. Courts can often require probation terms that are not tailored to the individual offender as well. One example is alcohol restrictions, which are often put on even if unrelated to the offense. And as we've talked about on the floor and in committee, probation also restricts civil rights like voting, but hopefully not for much longer. Another concern with our probation system is that it is applied unequally. Before the Sentencing Guidelines Commission acted, in some parts of Minnesota, the average probation length was 3 years, while in others, it was 7 years. Even since the Guidelines Commission's action for judicial departures from the 5-year cap in 2021, there were 52 judicial departures in the 7th Judicial District, while there was 1 judicial departure in the 4th Judicial District and 0 in the 6th Judicial District. This fails the basic test that justice should be applied fairly across geography. 5-year probation caps are common in other states. This includes peer states like Missouri and Iowa. It also includes states that aren't typically viewed as soft on crime, like Alabama and Mississippi. Prior to the Sentencing Guidelines Commission action, 87% of felony probation sentences statewide were already under 5 years. Research also shows that probation revocations are far more likely to happen in the first 3 years. From 2002 to 2012, 1% or less of offenders had their sentences revoked after 5 years. Long probation is not rehabilitative. Research shows it is no more likely for a person with a long probation term to commit a crime than one with a 5-year probation term. Probation officers have all the information they need to determine whether an individual is fit to remain in society after 5 years. So what's happening in year 15 or 20 or 40 of a probation term? Well, not much, except taking up space in a probation officer caseload that could better be targeted towards those who are greater at risk, and waiting to see if they made a mistake that could send them back to prison, even if they've met all their probation terms for years or even decades. Between 2001 and 2021, over 36,000 people in Minnesota were sentenced to probation terms longer than 5 years. I don't know exactly how many of these individuals are still on probation, but I know that it's too many. Efforts to cap probation lengths at 5 years have long had the support of a broad group of stakeholders. Correction Commissioner Schnell wanted me to mention that he is in full support of this bill today, and I know that we also have some testifiers here to speak to the bill, if that time is now, Madam Chair.
All right, thank you. Looks like we've got Jennifer Schroeder here, so welcome back to the committee. Introduce yourself and begin your testimony.
Chair Mueller, Vice Chair. I'm Jennifer Schroeder, and I believe I've testified in front of some of you before. So just because we're running a little low on time, I'm going to spare some of my backstory. But a little bit
And I'm
about...
just going to interrupt you for 1 second. Sorry, I forgot to announce that we do have until 12:30 because hearings were canceled last week because of the snow. We had permission today to go until 12:30. So if your stomach is grumbling and you're ready for lunch, we've got you until 12:30. So go ahead.
Okay. Well, then I will just go with what I was originally going to. My story starts out like so many former addicts. I come from a broken home full of broken people. My addiction slowly consumed me until it was the only thing I knew, and looking back, it's unbelievable that I wasted 25 years of my life in addiction. What changed everything was the day that my newborn daughter was taken from the hospital. She was tested positive for drugs, and I got pulled over 3 weeks later. I had got sober, but I was still selling drugs because that's the only thing I knew how to do. I used with my parents since I was a kid. I grew up in a home that addiction was normal. I was bounced around from foster homes, group homes, you know. I was so relieved when I got pulled over because I was exhausted. I was so exhausted from living that life. So I just hit the ground running, and I was sentenced to a year in jail. I got pulled over, and so I got a possession charge. Just a possession charge, that's all I got. I was sentenced to 40 years of probation. I served 1 year in jail, and my rights were terminated to my daughter. She was adopted out for a possession charge. And this lit a fire inside of me, and I hit the ground running. I went to college. I was busing 2 hours to go to school one way because I had nothing when I got out of jail, nothing. I had no credit. I had no license. I had no family support. I had nothing. I had to rebuild my life from the ground. And then on probation. So I was busing all the way back to Wright County to go to probation meetings every 3 months. It was a lot of work that I put in, and I did this all under 5 years. So if somebody doesn't want to change their life in 5 years, they're not going to. The resources that we pour into probation and long terms, and not only that, I see, because I have got my degree in addiction counseling, so now I'm working in the field. The people that are violating on minor infractions and getting sent back to prison is astounding. And the fear that you live with if you're on probation and you're doing the right thing is still something that resonates with me every day. I could be in the wrong place at the wrong time, and I have a downward departure, so I have a 98 sentence that hangs over my head, or 98-month sentence. So I would go back to prison for 98 months if I violated my probation. For 40 years. I will be 71 when I get off probation for a possession charge. I don't know that I've met any people with violent crimes or any other crimes, to be honest with you, that have that lengthy probation. And I also served jail time, and my daughter was taken. You know, the disparities in sentencing, obviously, there's some issues there too. But I can tell you from my perspective, there is no reason to have more than 5 years of probation, because if you're not going to change, then you're not going to change. 5 years is plenty of time. I accomplished so much in 5 years. That's it.
Thank you.
Yeah.
Yeah. Thank you so much for your testimony.
Yeah.
Yeah. We also have Will Cooley signed up to testify.
Okay.
Welcome. Please introduce yourself and begin your testimony.
Chair Moeller, members of the Public Safety, Finance, and Policy Committee, my name is Will Cooley from the Minnesota Justice Research Center. I'm here to testify on HF 1607, introduced by Representative Jamie Long, capping probation sentences in the state at 5 years. So I don't want to repeat what the testifiers have already talked about, so I'll just give a little bit of overview on the research. Probation is designed to provide offenders the opportunity to stay in the communities, find or keep their jobs, and be directed to social services to help prevent them from recidivism. As part of our work at the MNJRC, we've been speaking to scholars, corrections executives, probation officers, and people on community supervision. This week, I had a probation officer give me an earful for 57 straight minutes on this issue. So we've been listening to folks. We've also been talking to victim advocates across the state. They've got lots of ideas on how to fix the system, but all of them agree that the growth of the state's probation population has overburdened local and state agencies, deteriorating the ability to provide the best returns on our public safety investments, deliver rehabilitation, and establish accountability. Two things are coming up over and over and over in these interviews. Not enough resources in community supervision, and we're not using our current resources in a smart way. A major factor driving the size of the probation population is excessive terms on supervision. As we've heard, in Minnesota, people can spend even decades on supervision. And recently, and in your packet, the libertarian magazine Reason focused on us, this state, right here, calling it the quagmire of criminal justice. So when probation terms are excessive, they can worsen outcomes, create unnecessary encumbrances to successfully completing supervision, and squander precious crime prevention resources. Capping probation terms can reduce the population of people on supervision, which allows for the redirection of energy and attention to the initial months of a term and to focus on individuals at elevated risk. So just quickly, a little bit on the research. Research from across the nation shows that the vast majority of clients could spend less time on supervision without an impact on recidivism. Oregon, a blue state, and South Carolina, a red state, have led the way on research by providing high-quality data. Among people who are on probation for a year without being arrested, more than 90% could spend less time on supervision. These findings demonstrate that by shortening probation terms, we can focus our resources on the people who are being rearrested. So you've heard the Minnesota Sentencing Guidelines Commission has already taken action. HF 1607 remedies the holes in what the Sentencing Guidelines Commission could do by making this retroactive. Thank you.
Thank you. We also have Carly Stark signed up to testify. Welcome back to the committee. Go ahead and introduce yourself and begin your testimony.
Thank you, Madam Chair, members of the committee. My name is Carly Stark, and today I am here on behalf of the Minnesota Association of Community Corrections Act Counties, also known as MACAC. We represent 35 counties that provide community supervision under the Community Corrections Act, which is about 70% of the probation population in Minnesota. We support this bill. We supported it back in 2019 and testified at the Sentencing Guidelines Commission. We believe in making decisions based on research and evidence, and the research shows that, after a certain amount of time, people are very unlikely to recidivate, and that time is actually, I think, around 3 years, maybe less. So this 5-year cap seems reasonable to us. We did some data collection in 2019, and it showed that 84% of cases that were discharged in 2017 and 2018 were less than 5 years, and then less than 10 years, I think, was 92% of cases. So we think that this is being followed through early discharge practices already, and we ask that you support the bill. Thank you.
Thank you. I don't have anybody else that I'm aware of. Any public testifiers? Nope. All right. I'm not seeing any, so we can open it up for member discussion. Oh, Vice Chair Feist.
Thank you, Madam Chair. I just wanted to speak up in strong support for this bill. I've been in the weeds with Carly Stark on probation legislation, and I just think this is really important. It's going to allow us to focus resources where they're needed, because we're not keeping people under supervision on probation longer than necessary, in some cases dramatically longer than necessary to protect public safety. And also, I've heard from a lot of experts about the issues of technical violations. Currently, I believe the last data, it was like $77 million that we spent on people who were incarcerated just due to technical violations. And so limiting probation is just going to alleviate that burden on the system and that injustice. And also, just as Carly Stark said, just we should, and Representative Long, we should follow the data. We should be putting our resources where they are most needed. And I just think this is a really important reform. Thank you.
Representative Hudson.
Thank you, Madam Chair. Not really a question so much as just some commentary on the bill and the environment in which it's being offered and the rationale for it. You started off in your presentation citing those statistics about where we rank nationally, 6th lowest incarceration, but 6th highest in terms of probation. And you used an interesting term that caught my attention, and that was the notion that we are by no means a low punishment state. And maybe this is a question. Is that the goal? Is the goal for us to become in Minnesota a low punishment state?
Representative Long.
Thank you, Madam Speaker. Thank you, Madam Chair, excuse me. Thank you for the question. So I think that sometimes I have heard members say, well, we are not incarcerating very many folks. We're just putting a lot of folks on probation. So the implication is probation isn't that big of a deal. So I wanted to help illuminate that it is a real big deal and that it does have significant impacts on people's lives. I think the goal should be effective punishment, effective sentences for individuals. So I don't know that low or high is necessarily the test. If I were actually following the data specifically, as Ms. Stark said, 3 years is really what the research shows about where probation is the tipping point for where it's effective or not effective. And a lot of other states are moving to a 3-year cap. So we're giving a little bit of a buffer here, I think, with the 5 years for allowing that there may be some inaccuracies in some of the research. But certainly there is no data I'm aware of that shows that after 5 years there's any meaningful effect for probation, depending that essentially you are just as likely to be committing a crime on your 10th year of probation as you are if you don't have probation.
Representative Hudson.
Thank you, Madam Chair. Thank you, Representative Long. I very much appreciate that additional context. And, when we talk about where the data leads and what's effective or isn't effective, the sometimes stated but not always stated premise is that the goal is solely to affect what we call public safety, meaning we want to prevent recidivism, we want to get the person reacclimated and to be a productive member of society. Again, it's very much focused on the perpetrator and getting them back in the saddle, so to speak. And what seems to be missing from a lot of these conversations is the criminal justice value of punishment. And that's why that phrase caught my attention of low punishment state, and accepting that low or high may not be the critical designation. I think for the folks in my district, for the folks that I know anecdotally, friends, family, folks that I chat with on a day-to-day basis, if I were to ask them, do you want to have a low punishment state to live in? Do you want to be in a state that doesn't punish crime or that punishes it at a low level? I'm pretty sure the answer across the board from almost everybody would be no. I do not want to live in that state where we're not punishing crime. And, maybe that's an inherent limitation in the fact that we consider this public safety as opposed to thinking in terms of criminal justice, because justice is about balancing the scales. It's about ensuring that people actually feel the gravity of the offense that they've committed because their victim was punished by their crime. And certainly there are examples of things that we consider crimes that arguably don't have victims, and I'm all about going through and reviewing those and seeing whether or not we're treating those properly. And frankly, I like the idea of limiting the utility of probation, but I'd like to do so in a context where where the end goal isn't having a low punishment state or a situation where we're just not addressing the punitive value of criminal justice, and we've taken that off the table as a whole. Thank you.
Representative Hollins.
Thank you, Chair Moeller, and thank you, Majority Leader Long, for bringing this bill back. I guess at the risk of going way too broad here, but my background, my undergrad is in research psychology, and I think that it's important for us to note that the punitive aspects of our criminal justice system are not actually something that deter crime. Crime doesn't happen because, or the lack of crime doesn't happen because people say, oh, like this is going to be a year of prison, but 40 years of probation. Like nobody's thinking about that when they do something. People, the vast majority of crime is out of desperation, right? I think we can agree that there is a desperation component to the reason why people commit crimes, and not something where a lot of it is premeditated. In fact, the things that are mostly premeditated and crimes that we should be going after, where people are thinking about them, are not, actually gone after in the same way. Like we don't have heavy punishments. We don't have a lot of punitive consequences for people doing white collar crime, where there are like millions and millions of dollars that are stolen from individuals. And in fact, these low level crimes, which could be violent, but could also be very non-violent, as in the example that we are given, are punished in an extreme fashion. And so I guess what I'm saying is I can see your point, Representative Hudson, that the people in your community are saying that they don't want this to be a low punishment state. But I also think it's upon us as representatives to make sure that people understand that there is science that shows that just because we have it on the books that we can put somebody in probation for 40 years, that's not going to deter crime. That's not what creates deterrence in this situation. And all it does is create an unjust system where certain individuals are punished for 40 years and other people are like given a slap on the wrist and asked to pay a fine that is like 1% of their annual gross income, right? And so really looking at this as something that is not only getting at the punitive aspect of it, but also an equity aspect of it. And when are we asking people to say, like, you have paid the price, and that price is, and we're done, and we want you to reintegrate into society and become full-fledged members of society, I think is really important. And I think that's what this bill gets at, because 5 years, as we've kept saying, the science behind it says that 3 years is when people are going to, recidivate. And if we wait 5 years, and nothing else bad has happened, I think we can pretty succinctly say that they have paid their debt to society for most situations. And if not, then why are you not in prison, right? I mean, like if it's a murder, then we're like, okay, yeah, 5 years is not long enough. But in most situations where you would be out on probation, we clearly think that you are able to participate in society. And we would like you to participate in society. And because of this, I think a cap on 5 years is really responsible. It's something that I think we should all get behind. And it's something that I think that we can, using science, using the data that we have provided to us in various capacities, I think it's something that we can communicate effectively to our constituents about why it's important to do this. So thank you. It was more of a comment and less of a question, but thank you for bringing this forward. I really appreciate it.
Thank you. Representative Whitty.
Thank you, Chair Moeller. I guess one of my questions would be utilizing the people that are out in the field. If a judge should be allowed to depart from the maximums, let's say there are compelling reasons to do so, would that be allowed? Because obviously they're hearing cases, and my fear is the shotgun approach that we think 5 years is it, but there's always those outliers that raise or lowers. And so having a judge who's hearing a case, can they raise that cap? First of all, is my first question.
Representative Long.
Thank you, Chair Mueller. Thank you for the question. So not under the current bill, no. And I have 3 concerns with going down that road. The first concern, as I mentioned, is that we are seeing real regional disparities in terms of how the sentences are imposed when you have the ability to depart. And that was true before the Sentencing Guidelines Commission acted, such that there are some judicial districts where the bill is almost not needed. There is no sentence imposed over 5 years, and there were some judicial districts where it was consistently imposed over 5 years. So that's one of the reasons why we have the Sentencing Guidelines Commission in general, is to try to have some consistency across region for the state. And unfortunately, we've seen that continue to play out even after the sentencing guidelines took action. They were not permitted to not have the ability for judges to depart in the authority that they have. And so they did allow for departures. But we have seen, as I mentioned, where, in 2021, there were 0 or 1 case in one judicial district and 57 cases in another judicial district. The second concern I have is, I think we've talked about the effectiveness of going above 5 years, which I don't think there is a demonstrated case for. And so I think as a policy-making body, we can let our partners in the judicial branch know what our policy position is on going above that. And then the third concern I have is that for some of the departures we've seen, they have gone up to that real extreme level. So there have been several that were 20-year departures for probation terms, and I just don't think, we don't really have a, maybe you could make an argument on the margins, but when you're getting to 20 years, there's no real case I can see to be made for something like that.
Representative Woody.
Thank you for that. I understand the 20 years in that. I'm just looking at that 5 and going up a little bit. I did ask someone that's a probation officer right now, and asked them, and they said the set parameters. So if they're doing well, yeah, cap it at the 5 year. But also, if they're not, it holds them a little bit closer. So if there would be a way to kind of give our probation officers out in the field that tool, that there could be a hearing that raises it if they feel the need to do or something, I think would be helpful just from them doing their job out there. Instead of them knowing, hey, I gotta do what I have to do for 5 years and then I'm gone, just a thought.
Ms. Schroeder, did you want to comment? I couldn't tell quite if you were, come back up to the microphone here.
It's just, yeah. I was just wanted to speak on that, on what you're talking about, because, so probation officers, and this is coming from somebody who's been on probation, can be biased in situations where, and this you're seeing a lot in the Black community, unfortunately, will violate people on things that aren't even big violations. So like giving the probation officer the power to extend a period of probation can be bad too, because there's a lot of people that are getting violations that don't deserve violations from probation officers, and that's just the truth. In my case, fortunately, I had a very great probation officer. She was at my college graduation. She's awesome. But this is different from Hennepin County and Ramsey County, where you see a lot of times people getting violated for no reason. So if given the power to extend it, I just think that 5 years is 5 years, you can accomplish so much in 5 years. And if you're not wanting to change and you're violating, then like she said, you should probably be in jail then. Honestly, that's just what I have to say. Thank you.
Yep. Let's see, Representative Curran and then Novotny, and we'll close it up. We do have testifiers here for the next bill too. Go ahead, Representative Curran.
Thank you, Chair, and thank you, Leader Long, for this bill. And I just wanted to make a couple of comments first on, if we're looking at, if Minnesota, how we handle crime and how we deal with recidivism and all that. And I think I really like the way that you described it as we're not a low punishment, we're not high punishment, and that certainly shouldn't be goals. I share that belief. I think we should be effective. And what I'm hearing is that after 5 years, probation just is no longer effective. And I think part of the concern that all of us share is having folks who commit acts of violence against other people. Are we making sure that that's not happening again? So I guess my question for you is, when we have acts of violence, when we're limiting probation to 5 years, does that have any effect at all on the incarceration sentence that somebody might have for committing acts of violence against someone.
Representative Long.
Thank you, Chair Muller. Thanks for the question. So I will note that we exclude homicide and criminal sexual conduct as the Minnesota Sentencing Guidelines Commission did. So those crimes are excluded and can have longer than 5-year probation terms. In terms of other acts of violence, so the research doesn't really distinguish that there are certain types of crimes where probation suddenly becomes effective after 5 years versus other types of crimes. So I do think it will be taken into account, certainly on a prospective basis when you're looking at the sentence, I would imagine, for some cases. But I think even when we're thinking retroactively for where there were certain sentences that were imposed that were above 5-year probation, I can understand why there's been some hesitation in the past around retroactivity there. But I would just posit that when we have so much data at this point showing that there is no benefit for having a probation term beyond 5 years, I don't think there's a good argument for allowing that to continue even retroactively.
Thank you. All right, Representative Novotny.
Thank you, Chair Muller. Just want to push back on a couple of things. Being on the Community Corrections Task Force last summer, I understand it's very expensive to run the program, and it is a program that is stretched, and I would like to see the resources focused on the people that need the most supervision to get them back on the path that they need. And it's been touched on a couple times, but Representative Long, you said, people are saying that we're a low incarceration state. We're not saying we're a low incarceration state. We are, in fact, a low incarceration state. We're, depending on the year and what matrix you use, at least in the low 5. So it's not that we're saying it. It's true. To the testifier, I would argue absolutely 40 years is too long. And I don't know, without the background of your case, how long it's been, but what's that?
10, I'm on 10
10.
years.
By your own admission, it seems to work, though. And I don't want to pull any information out of that you don't want to give, but I believe there was probably a plea deal involved in that sentence.
Yeah, go ahead, Ms. Schroeder.
Yeah, there was not, I got a downward departure. I left it in the judge's hands. There was no plea deal. I pled guilty and the judge sentenced me freely. There was a downward departure, so yeah, there was no plea deal.
Representative Novotny.
Going on to what the county attorney has questions about this too, and Majority Leader Long, I hope you address those issues. I agree with them. They have concerns, as do I, about the retroactivity, going back and automatically looking at changing law, revisionist history. They'd like to see a public process for this, and so would I. I just feel that at a minimum, we should bring the public into this. Don't see a process for victim notification if they will even be involved in this. I hope before this comes to the floor that those are addressed. I think they're valid concerns that we should bring it in. Thank you for putting the exemptions for criminal sexual assault. That is the one thing that I absolutely think that there must be, because I can tell you from many cases that I involved that is something, especially when it involves criminal sexual assault on minors, that is something that should be absolutely in thing. But there's other cases, as the County Attorneys Association points out, that they should be having the ability to do an upward departure on that, given the substantial and compelling reasons. So I think that not having any mechanism is also not good for justice overall, and I hope that you look at amending that before it comes to the floor. Thank you.
Thank you. Closing comments, Representative Long.
Well, thank you so much. Well, appreciate the comments, Representative Botny. I didn't hear Ms. Schroeder say that the 40-year probation term was what got her back on track. I think she said that having the opportunity to work with an excellent probation worker got her back on track and within a 5-year timeline. I will just mention, I really appreciate Ms. Schroeder coming up here for many years to share her story, and a real success story, graduating with a 4.0, being out there giving back and doing addiction recovery support. It's just extremely impressive. And it sounded like there was unanimous agreement that the situation Ms. Schroeder is facing is incredibly unjust. And she's not the only one. I've met with many others who have extremely long probation terms. As I mentioned, even after the Sentencing Guidelines Commission, we're still seeing 20-year probation sentences. So I do think this is necessary, and I just thank the members here for hearing the bill today and look forward to continued conversation.
Thank you. And with that, I renew my motion and lay over House File 1607 as amended. Thank you again to our testifiers. Really appreciate it.